On the iPhone, just admitted to the courtroom. Would you please identify yourself, ma'am?
Tatiana Velez.
Tatiana Velez, is that correct?
Yes.
Okay, you're here for your 9 o'clock?
Yes.
All right.
Or he's kind of like playing dance.
All right, so we're on the record in docket 24000159. That's people of the state of Michigan versus Christopher Magoon. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Schroeder.
And Assistant Public Defender Aaron Schroeder on behalf of Mr. Magoon, who is present and standing to my right.
And sir, you are Christopher Magoon, is that correct?
Yes, sir, Your Honor.
Thank you. This is the time set for a, what did she set this for? A final pretrial in the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I believe this is going to be a plea to count 1 and count 2 of the complaint. Upon successful plea, the balance of the complaint would be dismissed, and there is an agreement to restitution to, I believe it's Brian Cataline, in the amount of $1,000. Oh, and a Killebrew no upfront jail.
That would be $1,000. And then Killebrew. Upfront jail. This is a no contest plea.
Yes. For civil liability.
All right, and then there's the counts would be. I'm gonna make sure. So which counts? Because yeah.
I believe it would be counts 1 and count 2.
Counts
what I
one.
have.
Okay.
Or we could do count 4 because that's technically the count with the restitution.
Which count do you want?
I think maybe count 4 just for clarity's sake in the future, since that's the one that restitution is being sought on.
I mean, let's see, there's no difference. in
There's no,
that-
if the
in
charge is the
actual-
same, it's just which
Yeah,
car.
I think, yeah, that's so,
It's the same charge.
That's fine.
All right,
that's
yeah,
actually a 90
That's
day,
fine.
is that right?
Clear, yes.
Count 4 is a 90 day?
Yes,
Yep, they're
correct,
both
yep.
90s.
So which ones would the no contest plea to count?
Count 1 and count 4.
Count 1 and count 4.
Yes, I will update.
Thank you.
And then we'll dismiss count 2 and 3.
Correct.
Unsuccessful sentence. All right. All right, Ms. Schroeder, may I inquire of your client of his advice of rights on his no contest plea?
You may, Your Honor.
Okay. You understand in this no contest plea, count 1 is a punishable by 1 year and or $1,000, and count 4 is punishable by 90 days and or $100. There is a Killebrew agreement of no upfront jail. So if I was going to divert or do something different than the Killebrew agreement, you'd have the opportunity to withdraw your plea. Do you understand that?
Yes, Your
All
Honor.
right. You also have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have the witnesses against you appear at trial, to question any witnesses that are brought against you. You are represented by Attorney Erin Schroeder today. She would be present to cross-examine any witnesses, contest any charges brought against you. You have the right to have the court order any witnesses appear in your defense, remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your no contest plea is accepted, you give up the claim that the no contest plea was a result of any promises other than when stated on the plea agreement or threats that it was not your choice to plead no contest. You're also giving up the right to any jury trial or bench trial because you want to be having a trial. You'll be pleading no contest instead. Is it your decision today to waive your jury trial rights and plead no contest to counts 1 and counts 4?
Yes, Your Honor.
All right. So I'm in possession of the police report, and that is case number 235191060 that was provided by me by the defense attorney. Is this what you'd like me to use for a factual basis concerning counts 1 and counts 4, Ms. Wilson?
Yes, Your Honor, thank you.
Ms. Schroeder.
Yes, Your Honor, thank you.
All right. So I find that this happened, that it's on or about October 25th, 2023 in the city of Lansing at Larch and Cesar Chavez. That there appeared to be a collision, front end damage to a vehicle. And that was at Cedar Street and Kavanaugh Road in the city of Lansing. So as to count 1, the attempted R&O, it appears that Mr. Magoon was at the Quality Dairy on the south end and was approached by law enforcement. They were marked law enforcement at the time in uniform. And then he took off running after the accident, and they pursued him on foot. He slipped and fell in the parking lot, and he was taken into custody. It appears that so he knew that they were officers at the time and attempted to prevent them from the arrest, which is an assault, battery, wound, resist, obstruct, oppose, or endanger. That's Officer Tristan Brown and or Officer Patrick Mueller, police officers of Lansing Police Department. And they were both in uniform, marked in uniform. So they had reason to know that he was performing his or her duties. That would be count 1, the factual basis.
That's correct, Your Honor.
All right. And count 4.
And then it's for the attempt, correct?
Right.
Yes,
That would be
yeah.
the count 1 attempt.
Yes, all right, thank you.
And then the count 4 would be in regards to the 2003 Jeep Grand Cherokee. And that was the vehicle that was involved in the accident.
Nope, so it's gonna actually be, since we changed it, I'm trying to find,
All right.
Oh, the vehicle
The
description.
vehicle, yeah, because it's the 2022 Corolla.
Oh, yours was the Jeep?
Yes, ma'am.
Gotcha.
Oh,
Here it is, the 2022 Corolla.
okay.
So yeah, the 2003 Jeep Grand Cherokee was in an accident with the 2022 blue Corolla and was not reported immediately after. Or did not, or failed to stop at the vehicle scene. It appears you ran after the event, which would put you in violation of complying with the requirements of 257.619 under the Motor Vehicle Code, which is to stop at any property damage accident where the vehicle is intended. Should. So I don't have anything on the factual basis. I have the vehicle, his vehicle, but there's nothing written on the Toyota Corolla.
That may have been my oversight, Your Honor. I am trying to.
So if you have anything that would, I think we get the gist of it. I just would feel more comfortable if I could read a police report involving indicating the blue Toyota, where there was damage to the 2022 blue Toyota Corolla, since that's where the restitution seems to lie. Is the owner of the blue Toyota Corolla? No, that's a different victim, right? That's not Mr. Corson.
No, I do have up on my computer the crash report that does indicate the damage that the,
As long as you stipulate to those facts.
okay,
Yeah.
Ms.
You wanna show those
Schroeder,
to
are you
Ms.
willing
Schroeder?
to stipulate that the Corolla suffered disabling damage?
Yes.
Yes,
Okay.
yes, we are. Thank
right.
you. Sorry about that.
So that would be the 2022 blue Toyota Corolla. And the owner of that vehicle was a Brian Cataline, and that was a vehicle that was also sideswiped.
Correct.
Okay. And the indication was that that vehicle was sideswiped by Mr. Magoon at the same date and time.
Correct.
Is that a fair statement, Ms. Schroeder?
Yes, Your Honor.
All right. All right, I find the factual basis coming from 235191063 and the indicated stipulation of facts by the attorneys. Anything towards a factual basis on counts 1 or counts 4 or count 1 or count 4, Ms. Wilson.
Not for the people, thank you.
Ms. Schroeder.
Not for the defense, thank you.
All right. I find the no contest plea to count 1 and count 4 to be knowing voluntarily and accurately based on the police report and stipulated facts. The reason for the no contest is civil liability. Is a potential for civil liability. And I'm going to refer this matter to probation. Mostly for the Killebrew agreement, since there's a Killebrew agreement, and they'll get to see the pink sheet for restitution. But I want them to review it for probation, refer to probation. So, Mr. Magoon, you should go down to the 5th floor, answer any questions they have for you, and they'll develop a report for me. And then we'll see what options are available to us at sentencing date.
Okay.
And the sentencing date will be
June 3rd at 1:30.
June 3rd at 1:30.
Okay.
So go ahead and answer any questions they have. And then on June 3rd, we'll see what options are available.
Okay. Thank you, Your Honor.
You're welcome.
Thank you.
I appreciate it.
Anything else for the record in 2400159, Ms. Wilson?
Not for the people.
Mr. Schroeder? Ms.
No,
Schroeder.
Your Honor, thank you.
All right, thank you, Mr. Magoon.
You're welcome. Thank you.
And Ms. Schroeder, you can take back the,
Oh, yes.
Police
and I
report.
want to speak with you just briefly in the hallway. Thank you, Your Honor.
I'll be out here.
All right, thank you.
Are we ready on?
We're on Colonel, Vicente Guevara, Rivera.
We're already
Hello,
on
Ms.
Marcy
Sutter.
Rivera.
Okay, Rivera.
Yes, or Guevara, Your Honor.
Rivera.
Guevara. Marcy Guevara.
Yes.
All right.
It's Guevara.
All right, so it's on the record in docket 23-03156. That's people of the state of Michigan versus Marcy Guevara. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Ms. Sutter.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Ms. Guevara, who's joining us via Zoom.
And ma'am, you are Marcy Guevara,
Yes, sir.
right? You can hear me all right, Ms. Guevara?
Yes, I can hear you clear.
All right, thank you. This is the time set for a final pretrial on the matter. Ms. Wilson, how are we proceeding?
I would defer.
Ms. Sutter.
Thank you, Your Honor. At this time, there has been an offer extended by the state. I've discussed it with Ms. Guevara, and at this stage, we would ask the court to schedule us for a jury trial.
Okay, so we'll keep on so we'll set this for jury trial. This was the final pretrial. And we'll set it for jury trial on
April 22nd.
April 22nd at 8 a.m. So we've set for jury trial on April 22nd at 8 a.m. So the jury instructions will be by the week before. I mean, both of you have done that, so.
Next Monday.
Yeah, next Monday, you know, the drill. And then, so yeah, April 15th will be jury instructions, and April 22nd will be the date of trial. Anything else for the record in 23-03156, Ms. Wilson?
Not from the people.
Ms. Sutter?
Not from the defense.
All right, so Ms. Guevara, we'll see you on April 22nd at 8 o'clock. You're scheduled for jury trial on that date.
Thank you so much.
That'll be in person, ma'am.
Yes, sir.
There you go.
Marcy, you're free to leave. Just remember to log in for your traffic hearing tomorrow.
Oh, okay. Bye.
Thanks.
I
Thank
didn't
you.
hear that I was okay to go. I'm sorry. Bye.
You're fine.
All right, and then Posadas Pizzala is on, or,
He's here in person. Your Honor.
okay. All right,
And then Ms. Jackson is as well.
all right, we'll do Jackson after.
Thank you.
Mr. Parnell is also
Gina
here.
Jackson. All right. All right, so we're on the record in docket 24-00759. That's people of the state of Michigan versus Hector Posadas Zavala. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Sutter.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Posada Zavala, who is standing to my right.
And sir, you are Hector Posadas Zavala, is that correct? Thank you. This is the time set for a final pretrial in the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. It's my understanding that this is going to be a plea to the charge with no objection from the people to 7694A status should the defendant be deemed eligible and to Killebrew to no upfront jail.
So it's a plea to count one, and then there's no objection to 769-4A status. And Killebrew of no upfront jail, is that correct?
That's correct.
That's correct.
Ms.
Your Honor.
Sutter, is that your understanding?
It is, Your Honor.
And then Mr. Posadas Zavala, that's also your understanding. You're going to be pleading guilty to count one, which is a 93-day misdemeanor and or $500. There has a potential penalty. There's no objection by the people to 769-4A status. And the lawyers have agreed that there's a Killebrew of no jail. If I wasn't to follow that, Killebrew, you'd have the opportunity to withdraw your plea. Do you understand that, sir? Oh, is that yes?
Yes.
Okay, thank you. Ms. Sutter, may I inquire of your client of the advice of misdemeanor rights?
Yes, Your Honor.
All right. You understand in this case, Mr. Posada Zavala, you have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have witnesses against you appear at trial, to question any witnesses that are brought against you. You're represented by attorney Lauren Sutter, and she would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that, sir?
Yes, sir.
You have the right to have the court ordering witnesses appear in your defense, to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give the claim the plea was a result of any promises or threats other than what's been stated on the record, and it was not your choice to plead guilty. You'll also be giving up the right to appeal anything from a jury trial or bench trial, since you'll be pleading guilty instead. Is it your intent today to plead guilty to count 1 domestic violence and waive your jury trial rights? Yes, okay, all right. I'm gonna have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Okay. I'm gonna bring your attention back to March 15, 2024 at 3101 Glenbrook, City of Lansing. Were you at the City of Lansing address on Glenbrook on March 15, 2024? Okay. And then who is Talia DeHublis to you?
She's my dating mom.
Okay. So you had a dating relationship and now she's the mother of your child. Is that correct? Okay. You're pleading guilty to offensively having contact with her, and that was not done in self-defense. Why don't you tell me what happened on that day that makes you guilty of domestic violence?
So when we were just arguing, and then it led to a fight, and then I tried to leave, and I put my hands on her.
Okay, so you put your hands on her, pushed her, or
Yeah.
all right, and you did not do so in self-defense?
No, yeah.
Yes, okay. So it's not done in self-defense when you intended to put your hands on her at the time?
Yeah.
Okay. Anything towards a factual basis, Ms. Wilson?
Just one thing, briefly, Your Honor, Mr. Posada Zavala, when you pushed, Miss Talia, she did not want to be pushed, is that correct?
Yeah.
Okay.
Anything towards a factual basis, Ms. Sutter?
Defense is satisfied.
All right. I find the factual basis to be knowing, voluntarily, and accurately made. I'm going to refer this to probation for the 769-40 status review and for the Killebrew review, and as you know, and various other, but those are the 2 main reasons. So, Mr. Posada Zavala, you'll go downstairs to the 5th floor. Stop in with probation, anything, they're going to do a report for me, okay? And then when I get the report, we'll see what options are available to us, all right? So we'll refer to probation and we'll set a sentencing date for
6/3 at 1:30.
June 3rd at 1:30.
And Your Honor, I just apologize. I will not be present that day.
Okay,
So I would either need to have another attorney cover it, or if it could be adjourned very briefly.
I don't see why it could be the following week.
Well,
For the
Perhaps we
week
should leave it
before.
as the 3rd, because I'm also out the Monday.
All right, but let's leave it on the 3rd then,
Thank you.
and then you can get coverage
And you said at 1:30, Your
at
Honor?
1:30.
Thank you.
So I'll see you again on the sentencing date of June 3rd at 1:30. They'll develop a report for me. Make sure you stop by the 5th floor so they get that report done. Anything else for the record? 24-00759, Ms. Wilson.
Briefly, Your Honor, as Mr. Posada Zavala mentioned, he does share a child with the complaining witness. There is currently a no contact order that I believe is preventing him from being able to see that child. The complaining witness is here in the courtroom, and she has expressed to me that she would be okay with third-party contact in order to facilitate parenting time.
Ms. Sutter,
Thank you, Your Honor. The defense would have joined in that request for third-party contact of the child.
do you have the victim here?
I do.
Ma'am, you can come up here. And ma'am, you should state your first name and last name for the record. You stay right there. Okay. How do you say your last name? DeWelbus. All right. And that's Talia, THALIADEUDEHUELBES. All right. And ma'am, you are the victim in this case. Is that correct? Right. And are you requesting third-party contact so Mr. Posada Zavala can have contact with this child? All right. Do you have a DHS case going on right now or anything along those lines? But I want to know if there's another order of the court going on. Is there any family court thing that's going on? I don't want to make an order and then find out I'm in violation of a family court order.
Correct. I don't believe that there is like an abuse neglect case pending.
Okay.
I do believe there was a CPS referral at one point. I'm not sure of the current status of that matter. And I don't know if there is a custody or parenting time case already.
All right. Is there any custody or parenting time case involved in this matter? I'm having trouble saying your name. DeWelbus, is it? DeWelbus. What I'm going to do is I'm going to have you contact, probation department's going to contact you. I want it in writing from them that you're okay with the third-party contact, okay? That protects you, it protects Mr. Posada Zavala, and it protects, and then you can figure out who's the third party and make all those arrangements necessary. That'll probably be done in the next 3 or 4 weeks, okay? It's gonna take some time, but as long as I get the report, that'll be considered. I'm not gonna do it today on my own because I want to see what else is out there, okay? All right. So probation will talk to the complaining victim concerning third-party contact, and then develop a report. As soon as I hear from it, as soon as they're comfortable, and they can email me at any time, okay? But I need to hear from them, all right? Because I don't know what else is out there. It sounds like there's no DHS case. Doesn't sound like there's any type of a referee custody case, but they'll do their research and they'll let me know, okay? All right. So make sure and stop by Mr. Posada Zavala. Make sure you stop by the 5th floor because that'll start the ball rolling, okay? And then they will be in contact with you, all right, ma'am? All right. Anything else for the record in 2400759? Ms. Wilson.
Just to clarify for both the individuals, so the no contact is still in effect right now.
Correct.
Just so everybody's aware.
Yeah.
So until you hear otherwise, continue as if the no contact is in effect.
Yeah. Until you hear from the prosecutor, myself, or from the defense attorney, the no contact order is still in effect. Okay. I just want to get something in writing. Okay. Thank you, Ms. Wilson. Anything else, Ms. Sutter?
Nothing further, Your Honor.
All right. You're all set. Thank you for your appearance today. Jackson, right?
I believe so.
Is he on Zoom? Is Mr. Jackson on Zoom?
Ms. Jackson's right here.
Ms. Jackson? All right, Ms. Jackson can come up.
Is there anybody else on Zoom?
There's somebody in the Union County Jail. Is that Ms.?
That's not it. Nope, not who I was looking for.
Fair enough.
And then Mr. Livingston is
He-
here on
I'm Mr.
Henry.
Willie Henry Clay or Willie Clay Henry. Can't remember which way it is.
All right.
Henry.
Willie Clay Henry, okay.
All right, let's do Jackson and then we can call do you need to speak with Mr. Livingston?
I've spoken with him. I don't know if he's spoken with his client.
Mr. Livingston, have you had the opportunity to speak with your client?
Unfortunately, I did meet with him last week. I have not met with him since Miss Wilson made an offer. So if we could do a breakout
All right.
session, that would be helpful.
All right, thank you. So I'm gonna have Mr. Clay and it's It's Willie Clay Henry.
Yes.
Yes,
Yes.
so it's Mr. Henry.
Good. So Mr. Henry and Mr. Livingston, we'll place you in a breakout room with your client.
Thank you.
And then Mr. Parnell is also an 8:30 that has been waiting for quite some time.
All right. All right, so we're on the record docket 24-00756. That's People of the State of Michigan versus Kadena Jackson. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Ms. Schroeder.
And Assistant Public Defender Aaron Schroeder on behalf of Ms. Jackson, who is present, standing to my right.
And ma'am, you are Kadena Jackson, is that correct?
Yes, I am, Your
All
Honor.
right, thank you. This is the time set for a final pretrial in the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. A subpoena was attempted to be delivered to the complaining witness in this matter. We had the incorrect address, so it was returned. However, I did speak with him late last week and he expressed that he has no intention of participating in this matter. He is not here today, so I expect a motion for the defense.
Thank you, Your Honor. Based on those representations, defense this time would make motion for dismissal.
I'll indicate that you had personal contact with the complaining victim and he's not interested. All right, with that understanding, I will grant the motion for dismissal from the defense attorney based on the prosecutor unable to proceed, based on their contact with the complaining victim who is not going forward in the case. This is dismissed without prejudice, which means the people could reissue if they choose to, but realistically, the case is dismissed today. Okay, ma'am? All right. All right. I'm going to sign the nollie pros on 24-00756 to that effect. Anything else for the record in docket 24-00756, Ms. Wilson?
Yes, Your Honor, briefly, there was a PA 53 violation that was submitted pretty late last week, so it wasn't set for today. I guess I will leave it to the court's discretion on what you want to do with that as well.
Your Honor, I'd say since the case has been dismissed, I think the PA 53 automatically went already.
What was the PA 53 is for no contact?
The PA 53 is the no contact. I guess I worded that wrong. It was a bond violation for alcohol consumption.
All right. Well, the case is dismissed without prejudice. And I'll, Ms. Jackson, with the case being dismissed, your bond, your PA 53, your pretrial order is also going to be dismissed, okay? Okay, you may have violated that. It has nothing to do with the complaining victim because you weren't supposed to drink alcohol. But I'm willing to let that go since we're dismissing the underlying file. Okay.
Okay.
Just understand that if there is a next time, you got to file your bond conditions. Okay, that's part of the reason why you're out. Is that part of the reason you're out is that we're guaranteed that you won't be drinking. All right. If that's a problem, then you may not be out next time. So act accordingly. Okay.
I understand.
All right. All right, so I will dismiss the PA 53. Actually, it's a bond condition. And I'll indicate per dismissal of underlying file. All right, so the bond condition will be dismissed, and the underlying file dismissed without prejudice. Anything else for the record in 24-00756, Ms. Wilson?
Not from the people.
Ms. Schroeder?
Just that my client would like to get a copy of the dismissal when she has someone's a chance. Thank
I've
you.
got it, and we'll provide you a copy of it, okay? All right, thank you. You're all set, ma'am.
Thank you, Your Honor.
Would she just need to sit here or follow Nathaniel, Mr. Nev?
Just have her sit there and you can bring her a copy.
And I'll get you a copy. I know that. Welcome.
And then who'd been waiting for a while?
Mr. Parnell.
All right.
And just for the sake of it, the eye roll you caught the end of was over myself, not you.
I give very little credence to eye rolls. We all do it. So,
This man who is
100% internally directed.
um,
I think any parent of girls tends to have a really good.
well, it's just, it's, it means everything to everybody. It's kind of like silence. It's pretty ambiguous.
Yeah.
All right, on the record in docket 24000746, that's people of the state of Michigan versus Larry Parnell. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Ms. Sutter,
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Parnell, who is standing to my right.
and sir, you are?
Yes, sir, Mr. Parnell.
Larry Parnell, thank you. This is the time set for the final pretrial in the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. The complaining witness in this matter was subpoenaed. I did have contact with him late last week. He indicated that he had a cancer treatment this morning, would be unable to attend, but even if he had been able to attend, he had no intention to. He is not here today. I expect a motion from the defense.
Ms. Sutter,
Thank you, Your Honor. Given the representation from Ms. Wilson, I would make that motion for dismissal today.
all right, I will grant the motion. Probably print it, and Ms. Sutter, if you could help us out. Should be Mr. Parnell. Let me take it so I can
Oh, I
sign it.
apologize. It's the
No
morning,
worries.
yeah. Forgetting what I was looking at.
This is not in your
Yeah,
job training.
that's okay.
All right, so I'm in possession of the dismissal without prejudice based on the people's representations in which there was personal contact with the complaining victim and some question as to the participation. I will grant the motion to dismiss without prejudice, which means the people could reissue Mr. Parnell if they choose to, but for our purpose today and realistically, the case is dismissed. All right, sir?
Okay, sir.
All right. Anything else for the record in docket 24000746, Ms. Wilson?
Not from the people.
Ms. Sutter?
Nothing further.
All right, good luck to you, Mr. Parnell.
Thank you, Your Honor. Do you?
Have a blessed day.
You too.
Yes.
Mr. Lewis in this meeting.
I believe we're ready on Mr. Schaff.
Yes, we are. He is present here in the courtroom, actually.
And then he's not currently represented, but Mr. Javon Hanks is also in the courtroom.
All right,
And I'll advise the court further on that.
all right. Mr. Shuff can come up here.
Yeah.
All right. So we're on the record in docket 22011797. That's people of the state of Michigan versus Stephen M. Shuff. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Sutter.
And Assistant Public Defender, it's okay. Assistant Public Defender Aaron Schroeder on behalf of Mr. Schuff, who is present standing to my right.
And sir, you are Stephen M. Shuff.
Yes, I am.
Thank you. This is the time set for a pretrial in the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. This matter was part of a global resolution that has now been completed. So the people would be moving to dismiss this file as part of that resolution.
Should go without saying, no objection from the defense. Thank you.
All right, so Ms. Schroeder, if you could, we'll print that out.
Okay.
And if you give it to me,
I think I have to sign.
yeah, I think you have to sign it.
And if I could get also, I want a copy from Mr. Schuff so he has it for his records, because he
Yeah,
need to show
yeah.
that.
So Mr. Shuff, you might have to wait for the copy since our court officer is getting other copies. But if
I
you-
can grab that.
Yeah, if you grab that.
Yeah, sir. Thank you. Now, who needs this first? You do. Okay. Thank you.
May I approach him?
You may.
I was gonna grab it, but okay.
Thank you.
Yeah. The dismissal. Yes.
All right, so Mr. Shuff, this is dismissed by the the assistant prosecutor in regards to the global resolutions and negotiations that previously occurred. So I'm going to sign this in docket 22-01797. It's dismissed without prejudice, which means that people could reissue if they choose to. Really a formality in this case. The global resolution and the negotiations are what led to the dismissal of the case. All right, sir?
Yeah.
Okay. And I will put in the file, and Mr. Neves can make you a copy. Anything else for the record in 22-01797, Ms. Wilson?
Not from the people.
Ms. Schroeder?
Not for the defense.
All right, thank you for your appearance today. We're all set.
So just get you a copy here so you can give it to the folks if they need it for whatever reason. Huh? All right. So grab a seat here and Mr. Neves will be back in there.
Thank you. Is there a Cynthia Spade on Zoom?
Yes.
Yes, there's a Cynthia Spade and there's a Tatiana Velez.
Yes.
So Miss Spade was set for final trial at 8:30. She was told last time to appear in person.
All right, and she doesn't have,
She is not represented.
all right, so let's put that on the record. Ms. Spade, you can unmute. Ms. Spade, you can unmute.
Okay.
So we're gonna put your final pretrial on the record. We're on the docket in 23-03634. That's people of the state of Michigan versus Cynthia Spade. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
And you are Cynthia Spade, ma'am?
Yes, correct.
All right. This is the time set for a final pretrial in the matter. Ms. Spade, you're supposed to be here in person. Do you have a reason why you're not here in person?
Yeah, and I actually have a piece of paper I can email you guys. I currently I've been having headaches and having a bad cough, and I went in yesterday and took a COVID test, and they tell me to be back by tomorrow, 3 days.
All right. So you have medical documentation as to why you're not in court today on April 8th. Is that correct?
Correct.
All right. So you're gonna have to mail that to our criminal department.
Okay.
You'll have to scan that and email it. I think you should scan and email it to the assistant prosecutor, who's Abigail Wilson.
Okay.
All right. So that's just to guarantee that there's a reason for you not appearing in person. Ms. Wilson, how did you want to proceed at the final pretrial?
Thank you, Your Honor. At this point, we are scheduled for a jury trial. I was hoping to speak with Ms. Spade in person here today to see what the status of the dog license. Obviously, she's not here today. As far as I know, there is no dog license yet, so I think we're gonna have to proceed to a jury trial.
All right, Ms. Spade, we're proceeding to a jury trial because you've not had the opportunity to speak with Ms. Wilson. Part of the reason why is that you didn't show up live here today. I'm assuming she could talk to you at any time prior to the jury trial.
She could, Your Honor, and we did speak previously, and this matter had been adjourned back in March because I was told that she was in the process of getting a license, and there has been no update since then.
All right, so I have 2 adjournments for compliance purposes in this matter. So Ms. Spade, we're gonna leave on for jury trial at this time. So the jury trial is set for April 22nd at 8 o'clock. All right, Ms. Spade?
Okay, thank you.
Set for April 22nd, 8 o'clock. That is live in person. And then you should provide documentation to the assistant prosecutor and to our criminal department in regards to why you're not appearing in person today. All right, sir?
Okay.
All right, ma'am?
Yep.
All right. So we'll set it for April 22nd at 8 a.m. Thank you for your appearance today. You're all set, Ms. Spade. All right, Ms. Velez, we'll call your case. So we're on the record in docket 24-00613. That is People of the State of Michigan versus Tatiana Velez. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Ms. Schroeder.
Assistant Public Defender Aaron Schroeder on behalf of Ms. Velez.
And ma'am, you are Tatiana Velez, is that correct?
Yes.
All right. This is the time set for a pretrial in the matter. Ms. Wilson, how are we proceeding?
Thank you, and I believe we're going to be requesting an adjournment for compliance purposes.
That is correct, Your Honor. Ms. Velez did provide proof of licensure and vaccination of the dog. However, I still need to obtain from her information regarding the other count, the dog at large. So I'd ask for a brief adjournment so I can secure that information.
All right. Now if I remember, this is a 2 count.
Yes.
Yes.
Yeah. All right. All right. So we're looking for an adjournment. What's the time frame, Ms. Wilson?
I would defer to Ms. Schroeder.
Ms. Schroeder?
I will say that Ms. Velez recently had a child. Could I get 30 days?
Sure. Yeah, this is the first request for an adjournment. So we'll adjourn for 30 days for compliance purposes.
We have 21 days or 60.
I'll go with 60. Why not?
May 20th,
May 20th at
9 o'clock.
1 o'clock,
9.
9 o'clock.
Okay.
All right, we've set this for May 20th at 9 o'clock. Ms. Velez, you have till May 20th to make sure Ms. Schroeder has the paperwork that she can provide to the assistant prosecutor in regards to compliance. All right, ma'am?
Okay.
All right.
What time again, Your Honor?
May 20th at 9 o'clock.
Thank you. And thanks.
Anything else for the record in 24-00613, Ms. Wilson? Ms. Schroeder?
Just briefly, Ms. Velez, I'll be in contact with you later today about further documentation regarding keeping the dogs in the yard. Thank you.
Okay.
All right, Ms. Velez, you're all set. Thank you for your appearance today.
Thank you.
Mr. Livingston, were you ready to go on Mr. Henry?
We are, Your Honor.
Let's do that. All right, so we're on the record in docket 24-00066. That is People of the State of Michigan versus Willie Henry. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Livingston.
Good morning, Your Honor. William Livingston on behalf of Willie Henry. We're both appearing via Zoom. Mr. Henry from the Ingham County Jail.
Thank you. And sir, you are Willie Clay Henry, is that correct?
Yes.
All right, thank you. This is the time set for a pretrial in the matter. Ms. Wilson, how are we proceeding, or would you like to defer?
I would defer, Your Honor.
Mr. Livingston.
Thank you, Your Honor. I've spoken to Mr. Henry about Ms. Wilson's offer. He would like to accept the offer, that being that he would plead guilty as charged to failure to register a dog in exchange for a dismissal of the dog bite. And I think additionally, it would be for time served.
Okay. And is that a Killebrew agreement to time served, Ms. Wilson?
It is, Your Honor, and I don't believe Mr. Henry is currently charged with the unlicensed dog. It would be a count 2 with count 1 being dismissed.
Okay, so it'd be an added count 2,
Correct.
but failed to register.
And I'm working on finding that PAP code.
Okay, thank you. And that's 90 and or 500,
I
same.
believe so. Yeah, dog strength. No, it's license.
It's 90.
That was written under the animal ordinance. I don't know what the state.
Yeah.
Failed to register.
Your Honor, I can provide that statute if you'd like.
All right,
That would be
That's-
cool.
yeah,
I have MCL 287.262.
so 287.362 would be the added count to a fail to register. Is that
28
correct? It's a 90-day under $500.
287.262.
262. Thank you.
And I have a 90-day misdemeanor, and then from what I saw, the fine was at least 10, but not more than $100.
Does that sound right?
That is correct.
Yeah. Okay. Do you have any indication of the time served in this matter, Ms. Wilson?
Let me,
Or do we?
no, because he's not in on this charge.
Okay.
Yeah.
I have him arraigned on this charge on January 9th. And then arraigned again on February 23rd.
Yep, looks like he was incarcerated on February 23rd.
Okay,
So a little shy of 2 months.
all right. And there was a bond set at $1,000, 10%.
I believe so, correct.
So we have at 30 days. I mean, that's. All right. Is there any restitution on the matter that you know about, Ms. Wilson?
Not that we have, Your Honor, no.
Did you want the probation department to look into restitution, or did you want to go to immediate sentencing?
I think immediate sentencing is fine.
Okay, all right. All right, Mr. Livingston, do you have any objection? I'm assuming you have no objection to immediate sentencing in this matter. It does not appear that there's any restitution.
I have no objection. I was going to ask for it myself.
All right, perfect. May I inquire of your client of his misdemeanor advice of rights concerning the fail to register?
Absolutely.
All right, Mr. Henry, you understand you have the following rights. My understanding is you're going to be pleading guilty to an added count to a fail to register a dog or an animal, a fail to register pursuant to 287.262. That's 90 days and or $10 to $100, depending. There's a Killebrew agreement of time served, an agreement between the lawyers. So if I wasn't to follow that Killebrew agreement, you get to withdraw your plea. And there's no objection from the assistant prosecutor or Mr. Livingston to sentencing you immediately today. Is that your understanding, Mr. Henry?
Yes.
All right. I'm going to read you your rights concerning this misdemeanor matter. You have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have the witnesses against you appear at trial, to question any witnesses that are brought against you. You are represented today by Attorney William Livingston. He would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. You have the right to have the court order any witnesses appear in your defense, to remain silent during that trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give up the claim. The plea was a result of any promises other than what's been stated on the record or threats that it was not your choice to plead guilty. You'd also be giving up the right to appeal anything from a trial because you won't be having a trial. You'll be pleading guilty instead. Is it your intent or wish today to plead guilty to count 2 and waive your jury trial rights?
Yes.
All right. I'm going to have you raise your right hand as best you can. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
All right, sir, I'm going to bring your attention back to October 21st, 2023 at the offense location of the city of Lansing, Ingham County. On that date and time, did you fail to register? And I'm going to say a pit bull mix named Tiny.
Yes.
All right. Anything towards the factual basis of Ms. Wilson?
Not from the people.
Anything towards the factual basis, Mr. Livingston?
No, Your Honor. Thank you.
All right. I find that factual basis is knowing, voluntarily, and accurately made. I'm going to do time served for 30 days, as indicated as part of the Killebrew agreement. I'm gonna waive any fines and costs. Also waive the crime victims' rights fee and the state fee. And we'll administratively close this file. So it's so the sentence is 30 days. 30 days. I do find there's no restitution pursuant to the prosecutor's representations. Anything else for the record in 24-00066, Ms. Wilson?
Not from the people.
Mr. Livingston?
No, Your Honor, thank you.
All right, you should be all set, Mr. Henry. You've got your time served, and that's your sentence today. All fees were waived on this case. Good luck to you, sir.
Thank you.
Thank you, Your Honor. Thank you, Ms. Wilson.
You're welcome.
Thank you.
In 24-00275, that's people of the state of Michigan versus Javon Hanks. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Sutter.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter. I'm appearing today on behalf of Mr. Hanks in a very brief sense, just to advise the court what is going on with his representation.
Right. And sir, you are Javon Hanks, is that correct?
Yes.
All right, thank you. Ms. Sutter, go ahead and make a record so that we understand where we're at here.
Thank you, Your Honor. Mr. Hanks has made application to our office and was appointed counsel from our office in another court. I believe someone in our office may have misunderstood that he was also applying for an attorney in this case. Ms. Schroeder and myself intend on clarifying and fixing that issue with our office. I would note once he has been appointed counsel in this specific case, it does need to be conflicted out, given we represent the co-defendant, and that is something our office will also be arranging.
Okay.
So given today, I would ask for a brief adjournment to allow us to get all of that in order.
And that's your understanding, Ms. Wilson?
If I could have a brief second. Your
Sure.
Honor. So in looking at our file, it appears that the 55th District Court case that the Public Defender's Office has filed an appearance on has the same co-defendant.
He has two cases in 55th. One we have kept because it's totally unrelated. One we have also conflicted out because of that issue. So he already does have conflict counsel in one case in 55th.
So that most likely would be the second conflict.
Most likely, but that's not my decision.
Yeah, that's not your decision.
Okay, yeah, so that's fine, yes.
So Mr. Hanks is waiting for counsel, and most likely it's going to be conflict counsel.
Yes.
Okay. So that's a good reason to adjourn this matter. He'll get conflict counsel. So let's adjourn what for 3-4 weeks?
I'd say 3 is probably fine. It should be hopefully quick to find co-counsel or
Right.
conflict counsel.
Especially if he's already got conflict counsel on another case.
Correct.
So adjourn to,
April 29th at 9.
April 29th at 9 a.m.
I'm not sure who would have been in this case. Melissa Hill should be.
We believe Alyssa Hill is a co-defendant.
It didn't come that way from the prosecutor apparently.
Well, my complaint has a co-defendant.
Okay.
Ours does not, she's right, but I know there's a co-defendant on the
Correct,
file.
yes.
Yeah, I know there's a co-defendant on the file, just from the nature of the allegation. All right, so this should be marked as a co-defendant file.
I believe so, Your Honor.
Yeah. And it's the co-defendant would be
Alyssa Hill,
Alyssa Hill.
who is represented by Ms. Schroeder.
All right. So we're gonna meet on April 29th at 9 a.m. The co-defendant is Alyssa Hill. I made that note, so it might have to be, what's that? I think the co-defendant is assigned here.
Yes.
Yes, we just had her
Yeah.
pre-trial like a week
Yeah.
And I
ago.
represent her on the
Yeah.
file.
Ms. Schroeder represents her on the file. All right, so anything else on the record on 24-00275, Ms. Wilson?
Not many people.
Ms. Sutter?
Nothing further, Your Honor.
All right, Mr. Hanks, we're waiting for conflict counsel, as you know. You should probably get in touch with the PD's office, or they will do your bidding for you in regards to getting you the conflict counsel. But we've set this date for April 29th at 9 a.m. All right, sir?
Yes.
All right, thank you.
Is that the right address phone number? Okay, good. I'm gonna put it in. Sorry, right there. Okay, let's get a better phone.
Did you want to go in this way?
Yeah.
Since she doesn't have counsel, right?
Not the last I know.
Ms. Way, we'll call your case. You can unmute.
All right.
All right, we're on the record in docket 24-00624. That is People of the State of Michigan versus Megan Way. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
And ma'am, you are Megan Way, is that correct?
I am.
All right. And you are unrepresented by counsel today, is that correct?
I requested a public defender. I don't know for sure if they got back with that when I came for arraignment, I think a couple weeks ago.
Okay, let me see.
She did apply, it appears at arraignment. I have not gotten an update from her.
Do you have an update? Because we don't have an update as to,
Let me look into that one more.
I thought Ms. Sutter had your files showing it as declined. That she declined representation. So there might have been.
She applied for it at arraignment
so.
and they denied it. I just didn't get it.
Hang on, let me see.
so we have your application at arraignment. And then,
She's not showing, Your Honor, for whatever reason, she's not showing in our system.
okay,
Let me try by the case number.
all right.
I may an issue with stuff. Yeah, I'm not seeing in our system where she has applied.
All right.
I will follow up on that.
All right, so Ms. Wilson, my thought process is an adjournment.
That's what I was thinking as well. Yep.
Okay. Ms. Way, it appears that we have you applied at arraignment, but the public defender doesn't have they don't have anything right now, it appears. So,
Okay.
so my guess would be that you should probably reapply just to make sure, call them. They may or may not have you in the system. Is that the safest bet, Ms. Schroeder?
Yes,
Yeah.
yes, Your Honor, that probably will be. I will also put in an email
All right.
to ask somebody to start looking to see if we have an application somewhere that just didn't, that got lost. I mean, it's totally possible
Right, right.
with the amount we
So
process.
I will adjourn it for reapplication to the public defender's office. We do have you as applying. So it's probably a good idea to talk to somebody there just because it's a misdemeanor. And I think there's a 90-day on this. So it's a good idea.
Just for the record, sorry, Your Honor.
No.
Just for the record, I
Sure.
do want to state that I did get his license.
Okay. Yeah, so you probably should make sure the public defender knows that, okay? Because that's probably going real far towards compliance with what they're considering, but I can't speak for the assistant prosecutor. But if you've made application, you should continue that. I think that's the safest thing to do is continue application. So you should recall, do you need the number for the public defender's office or do you have it?
Yes, I do. I do not have that.
All right. So let me give you a contact number for that office.
All right.
I want to make sure mine's correct. 517-679-2979.
Okay. All right.
So yeah, since this is a misdemeanor, contact them, make reapplication, and we've adjourned this matter until 3 weeks. Don't you think? 2 to 3 weeks?
3 weeks should be fine together, because my suspicion is somebody either didn't turn in yet.
Right, right.
It got lost.
29th.
So we'll set it for April 29th at 9 o'clock. And ma'am, you can attend that by Zoom, okay?
Okay.
All right. Just call that number, make a reapplication. You can explain to them what happened and that we've adjourned the pretrial in order for you to follow up on the application of the public defender's office. Anything else for the record in 2400624, Ms. Wilson?
Nothing to people.
All right, Ms. Wade, you're all set. We'll see you on that April 29th date.
All right. Thank you.
You're welcome. All right, Mr. Duchette Barron, we're ready to call your case. So we're on the record in dockets 20-00697 and 24-00569. That is People of the State of Michigan versus Quentin Duchette Barron. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Sutter.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Doucette Barron, who is joining us via Zoom.
And sir, you are Quentin Duchette Barron, is that correct?
Yeah.
Thank you. And you can hear me all right, Mr. Duchette Barron?
I can hear you fine.
All right, thank you. This is a time set for a pretrial in the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I'm sorry, I missed it. Did we call both cases?
Called both
Okay.
cases.
So I believe that this is going to be a plea to the 2024 case, I believe, the malicious destruction of a building, but it will be an attempt.
So, and that would be, is that an added count too?
Added count or amended count, whichever the court prefers.
Do an added count 2 of attempt MDOP And is that still the 200 to 1,000?
Yes,
So the attempt is the same PAC code,
with the.
parents A.
Yeah,
So 750.3804 A parents A. That is a 6-month and or $1,000.
that is correct.
And with the A, I believe it goes down to the 90 days and 500.
What's that?
With the attempt, I believe it goes down to the. Or is it
No,
6 months?
the
Okay.
6 month is the half.
Okay,
Yeah.
That's an half.
Disregard me.
And then, but then with a plea to that file 24000569, the second file,
The retail fraud would be dismissed. And there is a Killebrew to no upfront jail and an agreement for restitution in the amount of 750. And I am working on the pink sheet right now.
so we would dismiss 20000697, and there's a Killebrew agreement to no upfront jail.
Correct.
Correct, Your Honor.
Then restitution is the pink sheet. What's the amount on the,
750.
and who's that to?
Peckham.
All right. So I will indicate that 20 docket 20000697 is to be dismissed per negotiations. Per plea on 24000569. All right, so Ms. Sutter, I'm going to restate that just so it's my understanding that Mr. Doucette Barron is going to plead to an added count 2, which is an attempt MDOP 200 to 1,000 pursuant to 750.3804A parent A, 6 months and or $1,000 with a plea to count 2. Count 1 is to be dismissed. There's also a dismissal of the pending retail fraud, which is 20000697. There's a Killebrew agreement of no upfront jail, and there's restitution to Peckham Industries for $750. Is that your understanding of the plea agreement, Ms. Sutter?
It is, Your Honor.
Mr. Doucette Barron, you understand that the ultimate penalty on a attempted plea to MDOP 200 to 1,000 is 6 months and or $1,000. Do you understand that, sir?
Yes.
You understand there's an agreement between the lawyers that you receive no upfront jail. If I was not to follow that agreement, you'd have the opportunity to withdraw your plea. Do you understand that?
Yes.
All right. And there's also restitution in the file that $750 be paid to Peckham Industries. You understand that, sir?
Yeah.
All right. May I inquire of your client of his advice of rights for jury trial on the MDOP charge, the added count 2, Ms. Sutter?
Yes, Your Honor.
All right. All right. So in this misdemeanor case of attempted MDOP, which is count 2, you have the following trial rights, sir. You have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have any witnesses appear against you in trial, to question any witnesses. You are represented by Attorney Lauren Sutter, and she would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. You understand that, sir?
Yes.
You have the right to have the court ordering witnesses appear in your defense, to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If plea is accepted, you'll give up the claim to plea result of any promises other than what's already been stated on the record, or threats that it was not your choice to plead guilty. You'd be giving also up the right to appeal anything from a trial, because you won't be having a trial. You'll be pleading guilty instead. Is it your intent today and your wish to plead guilty, to waive your trial rights and plead guilty to count 2?
Yes.
Okay, I'm going to have you raise your right hand as best you can. Do you swear or affirm that the testimony is, I forgot that. Do you swear or affirm that the testimony you're about to give is true to the best of your knowledge under penalty of perjury?
Yes.
All right. All right, I'm going to bring your attention back to December 13th of 2023 on 2511 North Martin Luther King in the city of Lansing. Were you at 2511 North Martin Luther King on December 13th, 2023 in the city of Lansing?
yes,
And at that time, did you attempt to, tell me what you did. Did you attempt to willfully or maliciously destroy or injure a building located at 2511 North Martin Luther King?
yes.
Why don't you tell me what you did?
I attempted to throw a rock at one of their smoke huts that they had in the back of the building.
Okay, so you threw a rock at the side of the building?
Their property, it wasn't necessarily their building, but it was a property on their, it was property
All
on
right.
their property.
And you knew that property belonged to somebody else?
Yes,
And your intent was to destroy or injure that building at that time?
yes,
And that's the building that was owned by Peckham, is that correct?
yes,
And that was an attempt charge, so the money doesn't matter, does it?
And
I believe it does because
Yeah,
it's still an element.
So,
I think she's right.
all right, so you knew at the time that creating the destroying or injuring the building would be costly to Peckham, even under the attempt charge of something less than $1,000,
yes,
but something greater than $200. Is that correct?
yes.
Okay. Anything for the factual basis, Ms. Wilson?
No, I don't think so.
Anything, Ms. Sutter?
Defense is satisfied.
All right. I find the factual basis for the attempt MDO building, MDOP or MDO building 200 to 1,000 to be knowing, voluntarily, and accurately made.
And Your Honor, if I may briefly before.
Right. Did you want to be heard on sentencing?
I would briefly, Your
Okay.
Honor. Thank you. I would ask the court here to consider immediate sentencing for Mr. Doucette Barron. There has been an agreement to restitution. I would also advise the court, Mr. Doucette, prior to my even being appointed to his case, wrote in a letter of apology that he would like to share with Peckham. I have shared it with Ms. Wilson at this time. If the court is interested in hearing it or seeing it, I'm happy to read it or send it to the court. But I don't believe that Mr. Doucette Barron is a person who is only going to be rehabilitated through the services of probation. I think this is a person who's taking more than the required amount of accountability for his actions here. And based on this letter that I certainly did not ask him to write, I've rarely seen a more apologetic and regretful person as to the actions that led to this incident. And I think with the agreement to the restitution hearing, or the restitution amount here, that he can be relied upon to make those payments without the supervision of probation. Thank you.
All right, Ms. Wilson, anything on immediate sentencing or allocution?
No, Your Honor.
Okay. Well, without any response for various reasons, I will go to immediate sentencing. I will follow the Killebrew agreement of no upfront jail. So I'll follow the agreement of no upfront jail. Restitution is to be paid to Peckham Industries for damage to the building for $750. So I'm gonna set $100 fine, $100 costs, crime victims' rights fee of $75, state fee of $50, for a grand total of $325. And that can be paid. Does your client need some time to make that? Because he's got a hefty $750.
That's correct, Your Honor. Yes, for the restitution alone, I'd ask for a little bit of time,
Yeah.
if possible, 4 to 5 months. Since
Yeah.
he is indigent.
What's that? He's probably $750 plus $325. I'm gonna refer to collections.
Thank you, Your
Yeah,
Honor.
that's probably easier, because that's over $1,000 that he's got,
Correct.
you know. So I'm going to refer the $750 and the $325 fines and costs to refer to collections. So, Mr. Doucette Barron, you should get with the City of Lansing Collections Department to set up any type of plan that you intend, and that'll keep you out of the show cause cycle. Okay, sir?
Okay.
And so, Mr. Doucette, I'll send you an email with information on how to get in contact with the collections department. You can disregard my earlier conversation about reporting to probation.
Okay. There's no need to report to probation. We'll just report to collections or follow Ms. Sutter's advice to report to collections. You've got $750 in restitution, 325s in fines and costs. So you're over that amount. You should set that up with the collections department. Other than that, there's no upfront jail, so you should be all set today. All right, Mr. Doucette?
Okay.
Right. Anything else for the record? And per the agreement, file 20-00697 is dismissed per the negotiations and plea agreement.
And Your Honor, I do have the nollie and the pink sheet would like me to approach.
Absolutely.
Thank you, Your Honor.
All right, so I'm in possession of the nollie on 20-00697, which is part of the plea agreement. And then I will place the $750 to Peckham pink sheet in the 24-00569 file.
Thank you, Your Honor.
Anything else for the record, Ms. Wilson?
Nothing, people, thank you.
Ms. Sutter?
Nothing from defense.
All right, Mr. Doucette Barron, good luck to you. You should be all set today.
All right. Thank you.
Thank you. Just have a seat in that chair and there's somebody on that screen?
Yeah, looks like they're getting ready for court.
But you're in that room. A5 room. Burgers.
that's gonna allow us to be on. And then you can make this bigger.
Yeah, they're not all in. Are we, oh, we're waiting. We're just waiting. Okay.
Okay. On
All
Tricia's
right, there we go.
S23, we can hear you, and so you should mute yourself because we're having a hearing. All right, thank you. All right, Ms. Schroeder, your appearance for the
Thank
record.
you. Assistant Public Defender Aaron Schroeder on behalf of Brittany Mastro, who is not here today not by her own doing.
Right. So, Ms. Wilson, it's my understanding that Ms. Moscow is presently in the Eaton County Jail, and we did writ her out. I have the writ, and it was done for that, and she was not brought over today. We have a previous writ on March. We did a writ on February 14th, and we did a writ on March 25th. So we get a third try. Okay, we'll do a third try. But after a third try, I'm not certain how to get her in, but to show cause the Eaton County Jail, because I don't know how to get her here.
I was definitely joking when I recommended that,
Yes,
but.
I understand that, but I don't know how to
You're the
get,
judge.
I don't know how to get Miss Moscow
Yeah.
here for what is a fairly straightforward sentencing.
Yeah.
There's not, I mean, there's not a lot of
No,
creativity to
no.
the sentencing, you know?
no, there's not.
And so we just need her attendance, and we can't get her here because Eaton County won't bring her over.
Yeah.
So, so with that understanding, I think I've made my part of the record,
Yeah.
Ms. Wilson.
The people are satisfied.
Okay,
You know,
so you're in line with the request for adjournment
Yes,
on this occasion.
and I did just pull up Miss Moscow's Ian case, and it looks like she has a sentencing there on April 18th. So maybe they will be more accommodating after that.
you know, why
That's
not?
reasonable.
I would hope so.
That's a reasonable statement. Okay, we'll adjourn sentencing. D was not
No.
brought over from Eaton County. The writ was done. That's the second writ was done. Ms. Schroeder, anything for the record?
No, Your Honor, except to just briefly add, I have not been able to, usually I use VineLink to verify where my clients are. I've not been able to get VineLink to work. So just to the best of my knowledge, she is in Eaton County. I just wanted to be clear that I've not been able to personally verify that. So I just.
That was the last information we had. We writ her out of Eaton County.
Okay.
That was on March 25th.
Per the online ROA, it doesn't look like she's posted bond in that
Okay.
case, so I would assume she's
All
still
right.
Very good. I just wanted to be clear on that. Thank you. Nothing further.
How far did you want to, what's the time frame for setting this out? It's got to be past the 2 week.
I would guess I would defer to the court on how long you think that you're gonna need to get a writ done.
She in circuit over there?
Yeah, she's in
Okay.
circuit.
Just wondering how much time.
22nd.
Okay.
22nd in the morning, maybe that's a work at 9.
Okay, April 22nd at 9 a.m.
Maybe the afternoons are.
Yeah, maybe
Yeah.
we'll try the morning because the afternoons aren't working. That seems reasonable.
Why not?
I got nothing.
Okay,
I'm not saying that.
so we'll set this for resentencing on the date. We'll do another writ to get out of Eaton County. Anything else for the record, docket 2301-848, Ms. Wilson,
Not from the people.
Ms. Schroeder.
Not the defense. Thank you.
All right, thank you. That's all on that file.
Pay this.
And then we have Mr. Perkins, who is,
He's downstairs.
Is he downstairs?
let's bring him up and then, did you have a question? No?
No, I was just waiting to go file. So that's good.
Okay.
Everybody's trying to
on Trish's S23, could you identify yourself, ma'am? You'll have to unmute.
Bobby Joe Guns,
Which person? Okay.
Say your name again, ma'am.
Bobby Joe Rogers or Guns?
Bobby Joe Rogers. All right, you're here for your 2:30?
Yes,
All right. And Miss Pereira, are you here on that case?
Yes, Your Honor.
All right. And then I have Mr. Sutherland from Silver Summit. And that's you, Miss Anderson?
Yes, it is.
All right. Well, let's, while we're gonna have a sentencing here, but let's go ahead and it's a non-public sentencing, but while we have everybody here, let's go ahead and call that civil case, okay? All right, so we're on the record in docket 23-02684. That is Silver Summit Home versus Bobby Joe Rogers. All right, so we can pick you up. So, yeah. All right, so we're here so appearances have been made for the record and we're here on 23-02684. I have a motion to set aside. Is that right? I have this set for motion to set aside. Oh, is this for the January 30th? We had neither party appear, and then it appeared that parties were negotiating and a conditional dismissal would follow. But if that initial dismissal wasn't set aside, we got a problem. I'm just looking at the notes. Miss Pereira or Miss Anderson, how are we proceeding today?
Well, so I think, sorry, I know that none of the parties filed a motion to set aside as far as I know. And so I think we're all wondering what this hearing is for, because we did, so that I know the trial, the trial was set for the January 30th, and we, right before the trial happened, we came up with a conditional dismissal and entered that. And then that conditional dismissal was, or there was a default on that. It wasn't, the terms of the conditional dismissal were not met. And so then I know I filed the affidavit and the writ and all other documents to get the eviction. Or about,
Is that
I
a
guess
fair
it was,
statement?
yeah, sorry, go ahead.
Miss Pereira.
Your Honor, yes, I do believe that what happened is they filed the the affidavit and request for a default, and then we got the notice of the hearing simultaneously. I will also advise the court as a sort of preliminary matter that our office is going to have to file a motion to withdraw from this matter. I did file that with my court system earlier today. The soonest I could get a date from the court for that, or from the clerk's office for that, was April 25th. And so at this point, if there is going to be a hearing, I would request that the court adjourn it for that April 25th date, so that our motion to withdraw could be, have the proper timeliness to be considered and heard.
All right, Ms. Pereira, I hate to tell you this, but I caught about every fourth word of that. I caught about every fourth word of that. So
I apologize, Your Honor. Is it any clearer now?
Yeah, a little bit. Yeah, as you get close to the microphone, it gets a little clearer.
Okay. So I agree with what Ms. Anderson stated, that they filed an affidavit and requested a writ enter, and then we received the notice of hearing at the same time. I also wanted to advise the court that our office did file a motion to withdraw as counsel. The earliest date I was able to get from the clerk's office for that was April 25th. And so I would request that any hearing be adjourned to that date, so that our motion to withdraw could be properly considered.
Oh, so you filed a motion to withdraw from the matter. Is that correct, Ms. Pereira?
Yes, I filed that earlier today.
All right. And I think I don't see a motion to set aside the dismissal, but I have a note here indicating on January 30th, initially neither party appeared. And then I have January 30th parties negotiating, parties to file a conditional dismissal. You're telling me that the indication is that's already been done, and then you filed a motion based on the failure of meeting the conditions. Is that right?
Correct, yes.
And so, but I know I don't have a motion to set aside. I don't have a motion to set aside. So I'm not sure. So I kind of agree with Ms. Anderson. I'm not sure why we're here, because I don't have a motion to set aside the dismissal that was filed by either party. What we have now is the possible failure to meet a conditional dismissal. And then Ms. Pereira, you've indicated that you filed a motion to withdraw on the case. Is that correct?
Yes, Your Honor.
All right. Well, I guess I'm not certain how we got here either.
It is scheduled for an additional hearing, as Ms. Pereira mentioned, that April 25th, for her to withdraw her motion.
All
So
right.
perhaps we should just adjourn to the 25th and.
All right. So Ms. Pereira, you're correct. The motion to withdraw has been scheduled for April 25th. Is that right?
Yes, Your Honor.
Yeah.
I would say, Judge, if there's nothing to be done today, I would say that I would imagine that this case is over. We can get the eviction, or that the eviction can be signed and executed, and there would be really no need for another hearing. I don't know what
I
the
would agree.
defense would be.
I would agree. I mean, that the motion to withdraw is separate than this. Right now,
Right.
I have a conditional dismissal that has not been met, and as long as that paperwork has been issued, and it could be electronically in the queue right now. Ms. Anderson, did you already file that?
Yeah, it was filed almost close to a month now, I believe. I think it's just been kind of postponed because of this additional hearing that was scheduled.
All right. Yeah. Do you see it?
I see that there's an affidavit filed, the affidavit of default and consent order that was filed on 3/15. And then the hearing was set by that motion for that paperwork was submitted to my file. And the civil department set this hearing here for today.
All right. So I'm going to indicate that the order's already been submitted, and it should be forwarded to me to sign.
Okay.
I don't think it's coming.
Yeah, I don't know. I don't know what's happened to it. But it's not where it's supposed to be. What I'm afraid of is they saw that there was a hearing and they set it for hearing, and then they waited to see what came out of the hearing. That's what I'm afraid happened, is that the hearing got set for some reason. I don't know. This is a motion to set aside hearing, but there's no motion to set aside a hearing on this file. So I don't know why it was set. But if you double check that and make sure it's submitted to me, I think I have all the conditions to sign it.
Okay, and if I can just file all of the documents again today, just to make sure that it all gets in there. I know I believe it's on my file. Last I checked, all the documents were there, so I don't know if you could just reprint them, or I don't know.
Well,
but I can file them again.
It has to be set in a certain file for me to sign it. So if you do refile it, make sure they know it's the second time you filed it.
Okay. I'll file everything again then.
I don't want to sign two out there, not recognizing the names on the document.
Right.
All right. All right. So I will await the order from the plaintiff and the indication it was already previously submitted.
Mm-hmm.
And then Ms. Pereira, we'll look at that 28th date for the next hearing on the motion to withdraw.
Your Honor, I think Your Honor, if a writ is entering today, that probably will moot my motion to withdraw.
Right. I don't think I've signed. Do I sign the writ? I don't think I've signed anything in regards to this file yet.
Okay.
So once I do that, you're absolutely right.
Okay.
So
I'll get those.
What I'm afraid of is they
today.
saw the hearing was set and they waited on everything for what order to come out of the hearing.
Right. would it be the best for me to submit again then, or I can be in contact with your clerks to see if it does pop up after a day or two after the hearing, or?
If you do resubmit it, make sure they know it's a second resubmission that you
Okay.
previously indicated, or you just
Okay.
might want to call and find out the status of it.
Okay, I'll do that
right.
one first. I'll call first and then I'll
Yeah.
resubmit if needed.
And Ms. Pereira,
Right.
you're right, that would end the representation pursuant to the signing of the order.
Yes, Your Honor, thank you.
All right. All right, so we'll leave it at that. I'll await the order to sign, or at least to be presented for signature purposes. Anything else for the record in 23-02684? Ms. Anderson?
I have nothing else, Your Honor. Thank you.
Right. Ms. Pereira, do you have any questions or anything of me?
No, thank you, Your Honor.
All right. And Ms. Rogers, you should be all set today. Thank you for your appearance.
All right.
What?
All right, I'm going to go off.